So in Vermont, though, before COVID hit, there was a bill put forward by the legislature that was paid and family leave. The bill provided for 12 weeks of paid leave to care for a newborn child and 8 paid weeks to care for an ailing family member. The amount of pay depended upon how much you originally earned in your job, and this was going to be funded through a payroll tax. Governor Scott vetoed this bill, and then the House fell short of the 2/3 vote needed to override by 1 vote. There also was another minimum wage bill, and this did pass through. It increased the minimum wage from $10.96 to $12.55 by 2022. And if you remember back in 2018, the proposal was to raise the minimum wage to $15. Governor Scott again vetoed this bill. However, this time both the Senate and the House did have enough votes to override the veto, so the bill did become law. And starting on January 1st, minimum wage will increase to $11.75 an hour, and then in 2022 it will go to $12.55 an hour. That's really it for new employment-related legislation. However, as we head into Election Day, we just wanted to remind everybody that Vermont does not have a law which provides for job-protected leave, either unpaid or unpaid, to vote. However, remind your employees if they start asking that Vermont does mail a ballot to every registered voter ahead of election. And flipping to the federal stage, there really wasn't going to be anything to talk about when we initially planned this presentation. However, at the very end of September, you guys probably heard President Trump issued an executive order titled Combating Race and Sex Stereotyping. And the headline was that this effectively banned federal employees, employers with federal contractors, or even recipients of federal grants from providing any training which includes a racial stereotype. In the executive order, it classified this type of training as a destructive ideology and blame-focused diversity training. And so that was why it said that this was no longer permitted. So within this order, it says that employers with federal contractors have to include 4 paragraphs within every contract. And the first paragraph lays out 8 different things that are now prohibited by anyone receiving federal funds, having federal contractors, or a federal employer. The first one is that these people may no longer teach that one race or sex is inherently superior to another race or sex. You may not teach that an individual, by virtue of his or her race or sex, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. You cannot say that an individual should be discriminated against or receive adverse treatment solely or partly because of his or her race or sex. You cannot say that members of one race or sex cannot and should not attempt to treat others without respect to race or sex. You cannot say that an individual's moral character is necessarily determined by his or her sex. Cannot say that an individual, by virtue of his or her race or sex, bears responsibility for actions committed in the past by other members of the same race or sex. Cannot say that an individual should feel discomfort, guilt, anguish, or other form of psychological distress on account of his or her race or sex. And lastly, you are not allowed to teach that meritocracy or traits such as hard work ethic are racist or sexist, or were created by a particular race or sex to oppress another race. So this was pretty big stuff. And then it also went on and says you have to include this definition of race or sex stereotyping. Then it also required that any contractor must send each labor union or representative a notice that they are committed to comply with this executive order, and you must post copies of this notice to employees and applicants. Additionally, the provisions have to be included in every subcontract or purchase order, and it must be binding on each subcontractor or vendor unless exempted by another rule. And then lastly, the most important is that if the contractor fails to comply with the above requirements or any additional rules related to this executive order, the contract can be terminated or suspended, and the contractor may be declared ineligible for future government contracts. So this was set out, and originally it was supposed to apply to all federal contracts that were entered into November 21st, 2020, giving people 60 days to understand the law and change any contracts that were about to be entered into. However, the Department of Labor already established a hotline to investigate any complaints about noncompliance that is up and running currently. And then additionally, the Office of Federal Contract Compliance Program made a statement that said training programs prohibited by the new executive order may also violate a contractor's obligation under existing Executive Order 11246, which is back from 1965 and prohibits discrimination based upon a protected characteristic or an employee inquiring or discussing about compensation. So basically they're saying you're not free from this order even if you're already in the contract, because if it violates the order coming down on November 21st, it could violate something right now. So then after this, again, this only came down on September 22nd, so less than a month ago, but there's been a lot of conversation about it. The Director of Office and Management and Budget issued a memo to the heads of executive agencies and the departments. And in this memo, he identified 7 words that could trigger a review of training materials. And those 7 words are unconscious bias, critical race theory, white privilege, intersectionality, systemic racism, positionality, and racial humility. So this is really what flagged everyone and caused all the panic. And we all thought, essentially, at this point, you can no longer teach implicit bias trainings if you're a federal contractor, federal employees, or recipient of federal grants. And then lastly, in this memo, the director created a new affirmative obligation that wasn't present in the original executive order, and that was that federal contractors are required to represent that they will not conduct much training even for their own employees. So again, this seemed really bad at this point. There was really no way we could go forward with implicit training. But then, of course, there was more guidance. And that was earlier this month, the head of the Office of Federal Contract Compliance Program, he spoke at an NYU School of Law conference, and he stated that actually unconscious bias trainings are perfectly fine as long as you teach that everyone based upon the human condition has unconscious biases. So, as you all know, last year, Ben and I did a presentation on implicit biases, and really a foundation of all these trainings are that everyone does have unconscious biases. So based upon this, it seems like implicit bias trainings, as they normally are fine to go forward. I would just advise really make certain triple check that you have the phrase that every single person has unconscious biases. And then moving into case law, we're going to start at the top at the Supreme Court. You guys are probably aware of the Bostic case that came down earlier this year. And this was really a combination of 3 cases because the law across the country was split on the issue of everyone knows under Title VII, you can't discriminate based on sex. And so the question was, does the term sex include sexual orientation and gender identity? And there was not a clear answer across the whole country. So one case, which was the main one, said an employer fired a county employee for unbecoming conduct when he participated in a gay recreational softball league. The second case, and this is the one that came out of the Second Circuit, which is where Vermont is, was that an employer fired a skydiving instructor because he mentioned he was gay. And the courts said that that was unlawful. And then the last one was that after 6 years of employment, a funeral home terminated a transgender employee because she announced she would be living openly as a woman. So the Supreme Court took this up and they said, yes, Title VII prohibits discrimination based on sexual orientation or gender identity because Title VII includes the word sex. This was an important decision. It was a 6-3 decision, and Justice Gorsuch, who was a nominee of President Trump, said in his opinion that it is impossible to discriminate against a person for being homosexual or transgender without discriminating against an individual based on sex. And that when an employer discriminates against a homosexual or transgender employees, an employer who discriminates on these grounds inescapably intends to rely on sex. So this doesn't really change much for those of us here in Vermont because, as I said, this was already the law in Vermont. However, I believe it was 26 states across the country did not have the same opinion. And so really what this opinion did is it made what we already had in Vermont the law across the country. So you shouldn't really be changing anything because you were already complying with this law, but it's a good reminder to do it and review and update your policies to make sure that sexual orientation and gender identity are protected categories. And again, continuous education and training to the workforce to make sure that all supervisors and managers are aware that you cannot make decisions because of sexual orientation or gender identity, which means transgender status. And then I'm going to pass it to Andrea.
Good morning, everyone. Thank you, Amy. I am Andrea Wright, and I'm very happy to be here with you this morning. I think that this is the first time I'm going to be presenting in this presentation. And the decisions that I want to share this morning are related to the Second Circuit courts. As Amy mentioned, the Second Circuit is where Vermont is located, and these decisions are going to be binding in federal district courts in the District of Vermont. The first one that we have here is Wolf v. Estrada, and this is ADA case. The question is whether the inability to perform a particular job that is caused by migraines and stress arising from that particular job can qualify as disability under the ADA. The claims that were brought by Ronald Wolf here are a claim from disability discrimination and failure to accommodate, as well as retaliation. Ronald Wolf was a sales representative for Bloomberg, and he claimed that he had migraines that left him temporarily incapacitated to do his work. In his self-identification form, when he began his work, he did not identify himself as having any type of disability. But when he started working for Bloomberg, he mentioned that he had some migraines that were related to his stress at work. At the time that these revelations came up, he had already had some performance reviews that were not so positive. In fact, he was reviewed that he has problem solving, and he had a struggle collaborating with his peers. During those months in 2013, he decided that he wanted to have internal transfer to a different department and a different location, specifically to Asia, because that could help him with this disability that he was claiming. The company, Bloomberg, denied that request because he was not in good standing internally. So he decided that perhaps if he was not a different location, that he could change supervisor. So a new supervisor would potentially help, and also requested medical leave. The request for medical leave was approved, but also that he was not assigned to a different supervisor. After another bad performance review, he was terminated from his employment. The district court agreed that he was not disabled under the ADA because he was able to do the same type of work, but under a different supervisor. The Second Circuit Court agreed with the district court and analyzed if this migraine condition, this severe migraine condition, was a limitation to the major life activity of working. Although that migraine affected his work, the plaintiff had acknowledged that the stress that caused these migraines was because he was working under his direct supervisor. But if he was transferred to a different supervisor, then he could have performed. So the court stated that where a plaintiff condition leaves him unable to perform only a single job or a specific job, and not necessarily a broad range of jobs, then the plaintiff has failed to establish substantial impairment to his major life activity of working. The second case is Lancy v. Systemax. That is also a Second Circuit court and is related to pregnancy discrimination and sex-based pay discrimination. The question here is if under Title VII, if pay bias claims require evidence of unequal pay for equal work. Here we're facing a scenario where a female, which was the VP of risk management, sued an employer and the CEO, the CFO of Systemax, alleging three different things. First, that Systemax paid her less than she would have received if she was a man, that System X retaliated against her when concerns were raised about her lower pay, and that she was fired because she was pregnant. So there's violations of different laws, Title VII, Equal Pay, and PDA. System X had hired this executive and promoted her to risk management, and raised her salary, but her salary raise was so little that she didn't perceive it, and she didn't realize it was in her check. When she brought this concern to the CFO, she mentioned that she wanted to be treated similarly to her male peers. And after asking for this raise, she received a raise, but she was still significantly paid less than the male department heads who reported to the same CFO. The male executive level peers were paid above the market rate, and she was paid below the market rate. After her complaints and her continuous complaint to the CEO and the CFO, the CEO demoted her and put her under the supervision of the general counsel of the company, and opened an internal investigation. And this internal investigation was related to a business expense. She went to a conference and she left the day before of the conference, and then the CEO was claiming that because she had left the day before, those were personal expenses and not reimbursable. To the company, she did not succeed in her response, and she had an inadequate response to this audit of her expenses, and therefore she was terminated that same day. Coincidentally, she had also mentioned days before her termination that she was pregnant, and to the CEO and the CFO. So to the district court, Lancy was not able to establish that her male competitors that were substantially equal to her position in order to claim this disparate treatment, and that there was not sufficient evidence of discriminatory intent. The Second Circuit, though, disagreed with the district court and analyzed the pregnancy discrimination under Title VII with a 3-burden shift analysis, whether she was in part of the protected class, she satisfactorily performed her duties, she was discharged, and there was a motive of, or an inference of unlawful discrimination to be able to claim that there was discrimination based on her, on a Title VII claim. The circuit court announced that there was a temporary proximity between the time that she disclosed that she was pregnant and the time of discrimination, the time of her termination, that could give inference to unlawful discrimination. Related to her Title VII discrimination related to her pay, they utilized the same framework and determined that there was a motivating factor to discriminate under sex, and she did not need to show that she had equal work and different pay under the EPA to assess that she was discriminated because of her sex. She only needed to prove that she was discriminated with respect to her compensation because of her sex, and not necessarily that she had performed equal work but received equal pay. Clearly, the Second Circuit mentioned that if this would not be the standard, then Title VII would mean that a woman who is discriminatorily unpaid could obtain no relief. It doesn't matter how egregious the discrimination was if there was no other man in an equal job in the same establishment at a higher rate of pay. So they couldn't have that as a standard, and she only had to sufficiently show that she was paid below the market rate in order to have an inference of discrimination. So the next case, the last case that I have for you is Resnick v. Marriott, and this case is a hostile work environment case, which also is the idea of this employee, Resnick. He was a server at the Marriott, and he complained to his company officials that he was subject to hostile work environment after he revealed that there were other coworkers who were stealing money from the company. They were and because he had revealed that he was being subject of unlawful religious and racial harassment. Rasmi was of Egyptian heritage and a devout Coptic Christian. And he received, as you will see in the next slide, this slide, that there were a lot of alleged insults, colorful insults there that I'm not going to repeat, but nevertheless was a claim that he brought up. He complained to corporate, but corporate, according to what he was alleging, did not come with a solution to his the investigation, and he was terminated thereafter. In a hostile work environment claim, a hostile work environment claim have to show that there is discrimination and ridicule that is sufficiently severe and pervasive to alter the conditions of employment. In this scenario, the district court determined that that the harassment or the insults that he received were not necessarily directed at Rasmi, and therefore the general anti-religion statements of this nature, because they were not directed, are just stray remarks at best. And the comments could not have altered his conditions of employment because he was not physically threatened at his work, and his work performance had not suffered as a result. The Second Circuit determined that there had to be an analysis of the totality of the circumstances, and that even though some of the insults were not aimed to the employee, that could be not the triggering point to determine if there is hostile work environment claims under Title VII. Our case law, and this is what the Second Circuit mentioned, is clear that when the same individuals engage in some harassment that is explicitly discriminatory and some that is not, the entire course of conduct is relevant to analyze a hostile work environment claim. So even if it's not spoken at or in the even if it's on the presence but not spoken at the person that is claiming hostile work environment, it could still constitute an hostile and abusive environment. And also that physically threatening an employee to support the Title VII claim is not necessarily one that needs to be proven. Physically threatening is not necessarily characteristic to be considered by itself under this type of claim.